Defender Service Corporation Board of Trustees meeting will be called to order. Will the acting administrative director please call roll?
Yes, sir. Board of Trustees, roll call. Chairman, Honorable Robert J. Torres Jr.
I'm present.
Vice Chairman, Honorable Alberto C. Lamaranda III.
Here.
Member Attorney Jacqueline Terlahi, Guam Bar.
Present.
She's present online.
Member Mrs. Donna R. Muñoz Pinata.
She's also
I'm
present.
present via Zoom.
And lastly, member Dr. Christiana S. Whitman.
Present. And she's in the boardroom.
All members present, Your Honor.
Yeah, we do have a quorum. Notice of the meeting was appropriately published on the 15th and 18th. The first item on the agenda is the approval of the minutes from the regular meeting of September 24th. So moved. It's been moved by presiding judge. Is there a second?
Second.
Been seconded by Tiana. All those in favor say aye. Aye. There being
Aye.
no objection, meeting minutes pass. Under old business, can we get an update on the financial status?
Yes, sir, Your Honor. Thank you. Good afternoon, board members. Last time I had erroneously reported in the previous board meeting that there was one more allotment for PDSC for fiscal year 2024. There was a transfer made in August from DOA to PDSC, which had not been recorded in our books. And now I am happy to report that fiscal year 2024's allotment had been completed as of the last board meeting. For fiscal year 2025, PDSC received our second allotment today to make a total receipt of $683,888. After the last board meeting, both PDSC and APD is operating at 87%. Fiscal Department will be issuing and submitting the allotment invoice for CLC as soon as the moratorium is lifted. In the meantime, the ARPA funding will be used, and after it is exhausted by this fiscal year, the local funding from the general fund will be used. ICJR and STOP. The ICJR is status quo until we receive the signed MOU for the additional funding of $31,489. We will issue our September invoice as soon as the MOU is received. An invoice for Stop 22 for August 2024 for $10,549 was issued, and the remaining balance of $16,510 is scheduled to expire in June of 2025. EJC. We had reissued the invoice for February by splitting the amount into two payments of $13,109 and $2,902 per the request of DPHSS. Other invoices which we are still waiting for payments are March and July for $1612 each, and August and September for $18,000.
I'm trying to wait. Hold on. I'm trying to look. I'm trying to get out of this.
Can you meet? No? Okay.
Yes, sir.
Go ahead.
The receivables from DPHSS above total to $85,864 from a total of $197,604. WestCare Legal Services for the Veterans. PDSC is still waiting for a payment for an invoice issued for September of $1,002.50, and that will be all for the fiscal for the accounting of the funds.
Your Honor, did you need a hard copy of his summary?
No, it's fine. Report, any questions from Mike on the financial status? If not, we'll go to the PDSC Executive Director's report.
Thank you, Chief Justice. So we did include in our report three different stats. One is the active caseload. One is one by judges, and then we have an electronic monitoring report. Looks like we had 76 applications, and really 36 of the 70 granted, 13 denied and the balance are pending. And this is, it looks like since January of
Yes, calendar.
this calendar. Pretty much EM is our default request for release at this point. The numbers, I mean, our case load numbers are pretty much static, the same as in 2023, 2022 prior years. And so pretty much everything else is status quo. I mean, I have other things to add, but I know we have a lengthy board meeting and other people have meeting elsewhere, so I'll just table everything till later on in the agenda.
All right, we'll go now to the report from the APD Managing Attorney unless anyone has any questions from the executive.
So is it true Derek really lives in Hawaii and he's just back in town?
Annie?
Oh, sorry, Your Honor. As far as, we have 2024 fourth quarter final up to date on the report. We have 83 cases for felonies, 18 cases misdemeanor, 18 cases, juvenile. So total for fourth quarter so far has been 122 cases. The rest of the average case time is on the report. We did just submit an electronic monitoring program stat. I know that Judge Lamarena is always interested in that one. So far we have pending vetted 48 EMPs, 14 considered ineligible, 7 people are homeless. Submittals have been 42, revoked is 18. So far, 24 EMP release, TPC release is 5, bail release 24, personal recognizance bail 269, 86 detained, 5 federally detained, and 8 detained who are under NGRI. One of the things that I think we're going to have to really look at too is those cases where the court makes us file not only PR, but EMP as well as file and pain. So that's kind of a separate category, but we do have those. That's not on here, but Magistrate Judge Kwan actually makes us do all 3 sometimes for high profile cases. I'll defer anything since we have a long agenda. So if you have any questions, you can go ahead and ask.
Any questions for Ms. Gale?
Thank you, Your Honor.
All right. If not, the next item on the agenda is the report from the CLC Managing Attorney.
Good afternoon. I know we provided statistics and that's for you guys to review. So I'll go ahead and also, I know we have a long agenda today. So if there's any questions on the statistics that's provided, please let me know. We also submitted, and you might have received the civil law indigent legal needs assessment that we've been conducting. We launched it about 3 weeks ago. So you have the statistics for about a period of 3 weeks, which is about 117 participants that answered the survey. We can table this because I know it's volumes. It's about 70 some pages of data that was collected. So we can table it so that you have time to review that if you guys like. And we can discuss it at the next meeting. But I just wanted to point out in this, you see that if you look at the stats and you can look at it, is that the participants that actually sorry, was that me that was echoing?
Sorry.
Oh, yeah. So in the statistics, there's questions. If you look at the household income level and you look at the, the household amount of people in the household and you look at the income bracket, if you just look at the data that was collected for household of 1, if we use our current guidelines, about 30-some%, almost 40% of the individuals that filled out this survey would qualify for services at CLC. So although it's not really I mean, I'm still looking at the data as well, but if you look at the income level of a household of 5, because if you look at the household levels in this survey, the greater numbers was between household of 1 to household of 5, which ranged between 15 participants to 20 participants that said they had a household in that amount. And then if you look at our income bracket of household of 5, about 60-some% would qualify for services answering this survey at this point. And the survey results also include the priority, whether they felt it was a priority to fund and provide these services, as well as whether they thought what kind of priority was it to them. So that's all in this survey. I'll table it so that we can discuss it further, but I just wanted to point that out. That's just like a short scenario of what I've read in the survey. And then the rest of the stuff, I guess we'll be talking about it under the civil moratorium, which is the subsection G of this agenda. So I can wait for that time, but I hope that you guys received the letters that was submitted to the board as well as the director from not only clients, but also from our EJC advisory commission.
All right. Thank you.
Thank you.
The next item on the agenda is the executive director's compensation and classification. This is an item under old business and is been deferred until the evaluations are complete of the executive director. And so that item will be discussed in executive session later on today. So we will talk about it. So this item will again remain on the agenda until it's addressed by the board. The Sixth Amendment Center project, Steve, do you
Your
want
Honor,
to
if I
just
may-
pass on that?
If I may go back onto that executive director's compensation classification, there is an attachment or an exhibit that's on page 29 regarding kind of a historic view of.
Yeah, that was under new business, the APD, Executive Director Performance Historic Summary.
Yes, basically the historic, of his current salary and backwards and where he.
Was that intended to be under new
I
business?
think it
under
was just mistakenly placed in the wrong exhibit, but it should be on page 29 with regards to that subject matter.
All right, so are you gonna report on that?
That's fine, I can.
All right, okay.
So basically on page 29, there's 2 charts there, or 2 tables. So the current, or the top chart, which says current, is basically from when ED Authority had started with the public defenders in 2016 to where he had received an increment in 2017. And then there was a pay adjustment to the pay scale, the executive pay scale, which also bumped him up, but not an increment, but rather an adjustment to the pay scale in general. And then in 2023 was the last time there was the final adjustment to the executive pay plan. And then the chart below, or the table below, just reflects that from the time he started, if every year there was an evaluation, then he would qualify for an increment every other year based upon his years of service. Then he would be at where he would be at currently in March of this year. So I just wanted to point that out, that this is, and granted, I'm not an HR or a fiscal expert, but I did consult with both departments and to try to clarify information and bring it as close as possible. But so basically the current pay scale that he's on is reflected on the top chart. The bottom chart is if he had been conducted an evaluation yearly and either given an increment or not, depending upon the board's decision. So that's all I would like to say on that matter.
All right, so noted, the
It's just
board has the
informative.
information that's prepared, and we'll take that into consideration when it looks at the classification and compensation
Thank you.
after completion of the performance evaluation. Then the next item on the agenda is the civil moratorium. And are you gonna speak to that, Carol, or?
Yeah, how,
Yeah, I can speak to that. So we had submitted a proposal or a proposed resolution, Your Honor, to lift the moratorium um, uh, at the Public Defender's Office and providing civil indigent representation. A survey was also sent out by the Guam Bar. I don't know if that's included in here, but it should have been given and provided to you guys. 14 of the Guam Bar members answered it, and the majority felt that it positively impacted the community and had no issues with lifting of the moratorium. And for the ones that did raise any concerns in questions 1 and 2, the concerns are concerns that have always been discussed before this board. Basically like conflict issues that is already a resolved issue, Your Honor. We're a separate office that doesn't, that is not a part of, that's not working out of the same office as the public defenders. We have our own database similar to APD. We're separate and distinct and independent from the public defender's office. So there is no conflict issues. I think the other concern was, of course, the budgetary restraints, but as in the past, public defenders has always been funded and the attorneys and its staff through local funding for the past 50 years or almost 50 years. Since public defenders was created, they've always handled civil indigent representation, and they've never stopped really, even with the moratorium. You know, they were given the authority to provide limited services, and additionally, services that were mandated by the legislature, such as the Guam war claims probate matters, which is stuff that was given to us after the moratorium was in effect still. So, and then I think some concerns were, of course, the concerns that the board had, but the resolution addresses, which is ensuring that we prioritize the needs of the kinds of services that we offer based on resources and capacity. So that was one of the concerns brought up. But for the most part, it was the conflict was the main concern. I think it was of the 14 that responded, there was about 4 maybe or 5 that brought the conflict issue up. As we mentioned, though, the conflict issue we believe is not an issue. In fact, by separating this office, it really, that issue is obsolete. It's not gonna, our clients are no longer their clients. And now that we represent the victims, there's no need for them to withdraw in the criminal cases where they represent the other party. And so so we're requesting that the moratorium be lifted. We do have letters of support from even our clients who actually were referred to this office by the private bar because they weren't able to be serviced. And then we also have a letter of support from our EJC advisory requesting it. I think one of the other concerns was us taking clients from the private community, the legal community, and that's not an issue, Your Honor. We're going to strictly adhere to the adopted guidelines by this board. So we are going to be representing people that are income eligible. The only way that they're not, we don't look at income is if we're utilizing our grant sources and which is limited again by age. It's limited by the type of work that is performed. So the federal grants limit the scope of what we can do under those grants. And that's the only time we're not going to look at income. Otherwise, we'd be strictly adhering to the income guidelines adopted by this board, and we'd only be representing clients who qualify income-based. And then, of course, as we have no difficulties advising this board as to the types of services we want to expand on. And this board, like in the past, in the last 2 resolutions, has permitted, limited work to be done by the civil division. We're really not a new office. We were a part of the public defenders, and we still are at this point. It was the civil section of the public defender's office. We only moved ourselves out so that we can eliminate the conflict issue that the court had and the attorneys had, and that issue is no longer, which was mainly the issue why the resolution was adopted, was so that public defender's office can focus on criminal defense and not conflict out. That issue is no longer there. I think the executive director has pointed that out in previous board meetings. And so at this time, we feel like lifting the moratorium would be appropriate, Your Honor.
All right, we tabled this resolution at the request of the trustee Terlahi. Jackie, do you have any comments? Are you still there, Jackie?
Yes, I'm here, Chief. Just having some technical issues trying to get a screen up on a different computer. So I've got two modules up just for purposes of the people who are handling the Zoom platform. No, I appreciate this board setting this matter for today's hearing to allow for commentary from the Guam Bar Association. We did allow for a period of commentary, and unfortunately, we had only 14 responses. Obviously, my concern is always to ensure that we give an opportunity to those who are affected and who have a relationship, the stakeholders essentially, to our system. I do understand that Attorney Jay Ariola intended to be present for today's hearing or today's meeting, but I do not know of any other attorneys in the Guam Bar Association who may be interested in appearing before the trustees to address their concerns.
Are there any attorneys online? Can you tell?
Yes. I did not see any. This is everyone online.
Okay, so other than Attorney Terlahi, instead of taking, Jay, did you want to be heard? And
I would like to,
Okay,
if the board will hear me.
instead of deferring his comment for public discussion, is it if the board approves, we can maybe hear from him, since I presume you want to talk about this resolution. All right, is there any objection to taking him out and instead of having him heard at public discussion, that he be heard at this point in the meeting? No objection.
No objection.
Thank you, Chief. I appreciate the opportunity to appear before the board. Way back when, I was in favor of the initial moratorium, primarily to ensure that the Public Defender Service Corporation and APD adhere to their primary mission, which is representing indigent criminal defendants. The impact on the private defense bar and the indigent panel may somewhat be alleviated today. Next week, next month, it may be impacted again. And although we hear the Civil Law Center indicating the issue about conflicts is no longer there because they are separate entities, we're still under one board. And I don't know whether this board or the agencies have a legal opinion from our Ethics Regulation Council that this format indeed is compliant with the ethical conflicts issues. I mean, we're litigating cases every day with the Attorney General's office and the lack of proper screens and conflicts in the engagement of cases. For instance, what role will Mr. Hattori have in reviewing anything in a domestic abuse victims case, civil case, versus people of Guam versus the perpetrator? Clearly, we're learning in the AG's criminal cases that certain screens have to be affected, filed. We just hired a prosecutor. All our criminal files have screens on them, and we have instituted the necessary precautions so that conflicts aren't exposed. It's my opinion that extending criminal services to civil legal services is goes against the primary purpose of criminal defense, and that is Gideon. When we say civil Gideon, there really is no civil Gideon. Show me a case that is civil Gideon, where an indigent is entitled to a free lawyer. We see the Guam legislature, giving you guys $1 million to help out indigent population. I think, first and foremost, my objection would be on the conflicts issues that are inherent. And I don't think that the establishment of a civil law center in a different office under the same board of trustees sufficiently addresses the conflict. I think there needs to be a completely separate department, if you will, agency, like Guam Legal Services or the Civil Law Center, if you will, have its own board. I understand that this all goes back to the bigger picture of indigent services and legal services to the community provided by the government, and perhaps the whole establishment of some new commission or the like. But I think the removal of the moratorium will only lead to further conflicts and impose upon the rest of the bar. We saw what it did. And it's gonna happen again, and it's gonna happen in ways where we have these conflicts and the public defender and APD still unable to meet all the needs of the criminal defense indigent community. And so we have banking lawyers and immigration lawyers committing malpractice, paid for by the courts. Something's wrong. We're not providing effective assistance. The training and everything that these public defenders have all revolves around criminal law. That's why you hired them. And let me just give the main and my biggest example of why public defenders should not be doing, for instance, divorce cases. That case is Ian McConaughey versus Bruna Patelli McConaughey, Richard Dirks' client, who dragged that case out till kingdom come, drove the fees up through the roof before Judge Ingalls, in a juvenile special proceedings, found that her claims of abuse against her child were unsubstantiated. And then after a trial, Judge Perez awarded sole custody to my client, notwithstanding the public defender's victim client, divorce client's efforts to obtain custody by filing claims of abuse. 2 trials. She dragged him through the mud, over and under, with her free lawyer. He had to pay tens and tens of thousands of dollars, whereas Mr. Dirks, who has a heart of gold when it comes to his victim clients claiming they were being abused, put up with her. And that was also part of the problem. A public defender who didn't know how to do a divorce trial. Not didn't know how to do it. I don't mean it that way. Who has no experience on the issues of a divorce trial. And probably most important, client control. Richard Dirks, for all his years of experience defending murderers and, you know, everybody who the victims, because of his nature as a public defender, treats that domestic case like a public defender case. No, you sit your client down and you tell her, you know, what the judge is likely to award or not award. And to this day, this lady is all over the internet criticizing our courts as the most corrupt courts in the nation, calling out Judge Perez. He's corrupt. He defends, you know, I'm the murderer rapist lawyer. And now they're fighting over custody in the States. And it's the prime example of domestic litigation going haywire when they have a free lawyer. They have no incentive to settle. They have no incentive to settle. Civil cases should settle, right? Criminal cases, okay, you don't have to settle. You have the right to a trial, take it, right? But civil cases, I'm worried about the lack of training and experience for the Civil Law Center and the public defenders to do these cases. I think the moratorium needs to be a little more restrictive. First of all, indigency. I agree that victims perhaps, well, victims causes the conflict issue, seniors, veterans. I guess the legislature has determined that they are the priority recipients, but I think the board needs to limit the type of services. I would not include divorce services. Divorce is not a right. I would not include any fee generating probate services. If they have land, they have money. And what I'm doing here is advocating on behalf of the private bar. When the government takes over legal services and starts to pay these lawyers higher than the private bar, but our attorney general just got a huge raise. They all did. The private bar cannot compete with that. We're down to how many? 100 lawyers in private practice? The largest firm only has 4 or 5 lawyers. The private bar is really already stretched thin and competing to have more competition from the government of Guam, paying you lawyers your very high salaries that are comparable to the private bar, plus. I think if we do a market survey in terms of what private lawyers charge and pay, we'll find even amongst our staffers, everything is competitive. All my staff got picked up by the AG's office. I don't have any secretaries. There's 3 or 4 of them over there. After they were trained by me. And they're hired as a paralegal 2 or 3 and paid twice the amount. I can't compete with that. Likewise, I can't compete with your senior lawyers, you know, Mr. Bryson here being an attorney for step 8 or step 10, whatever it is. I can't compete with that. And so from the private sector, from the private bar, we just asked the board to consider limiting the moratorium. Do not include divorce cases. It's not a right. If they need a TRO because they're a victim of violence, perhaps that's something that the legislature should consider. But you're not entitled to a divorce. And people who want a divorce should not get a free lawyer in order to essentially jerk the other side into having to spend all the community funds. Thank you, Mr. Chief Justice and members.
Thank you. Thank you, Mr. Ariola. I would note that the resolution that is put forth still talks about the qualification based on the income guideline requirements. I would also note that the enabling statute for the Public Defender Corporation has an express statutory provision to provide effective legal aid and assistance to those persons in Guam who are unable to afford counsel. And there's a specific section on civil matters to render legal aid and assistance to those who are in the greatest economic and social need of legal assistance and representation, but also making clear that they not accept fee generating cases and give assistance in civil matters only to those who would otherwise not receive such assistance. With regards to the conflicts issue, public defender and APD both are the same board composition, and the APD has functioned as a separate and independent of the Public Defender Service Corporation in terms of their cases and the management of their cases, even though they have a board of trustees that governs both of them. So, but thank you for your comments, Mr. Ariola.
Thank you, sir.
I appreciate it.
Maybe.
Yes.
Thank you. Thank you all. Have a good day.
Thank you, sir.
Is there anyone else who wants to be heard on this resolution?
Well, no, I just want to thank you for pointing out that the Public Defender Service Corporation, when we were first created back in 1975, did create a statutory right to civil legal representation and for indigents, right? We've been doing it since 1975. And so, and I know that Mr. Ariola was frustrated over that one case, but there are countless other cases where a wealthy husband takes advantage of a wife who cannot afford an attorney and pretty much gets their way in court with them. And, you know, my experience when we do domestic cases, because in 2003, when we first imposed the moratorium, we opened 200 domestic cases. We weren't trying to milk cases. We were trying to resolve them because for us, time was money. We tried to resolve them as fairly and efficiently as possible. So,
But there is a process when you have one individual in a marriage who has money or control of the money, to require them to fund the expenses of, and, you know, the courts have been, particularly when it's been asked for, to fund the lawyers of the opposing party.
yeah.
So I think this, I don't think the intent of what the type of work that PD should do, should necessarily be representing wealthy clients, even though one person doesn't have the wherewithal because one side is kind of secreted or set aside the assets. You use the, you know, the equity of the court, and, you know, there is a specific statutory provision that allows for the allowance to support the litigation expenses associated.
That's like the kind of cases we're doing where we would be fighting over custody of the family car, because that's how poor our clients are. The family car would go with whoever gets the kid that we give. And so we're not really gonna be taking money out of the mouths of the private bar. And, you know, I'm just advocating this because it's a statutory duty that we ignored really.
But the statute also doesn't reference domestic cases, right?
Oh, no, just
It says civil cases.
I'd like to point out the reason why I put the moratorium, because I was chairman of the board then, was there were two issues that were predominant. One was the term called race to the public defender. When both parties were indigent, the one who reached the public defender first, the person did not, was left out in the cold. And usually that person couldn't afford to have a lawyer either. And so the problem was that the person who got the public defender to represent them always prevailed in the case because the person who was the spouse who was indigent, because most cases, both spouses are indigent, okay? And they can't afford lawyers. So the old term was race to the public defender. We felt that that was very unfair to the party that did not, was slow in running to the public defender's office. And that was very prevalent at that time. Many people were complaining that I lost custody of my children because I didn't have a lawyer. My spouse had the privilege of having a lawyer. So he or she got custody of all the children. I couldn't fight it because I couldn't afford a lawyer and I didn't know what to do. The second was a conflict, and I've seen that constantly in my courtroom. It's gone down a little bit because I think you're more able to screen clients now. But it's happened recently where I had public defender represent defendant in a family violence case. The defendant was incarcerated. The lawyer for the public defender's office was asking that the defendant be released on first PR. The victim opposed it. But who was representing the victim? The civil law center. Public defender was fighting against public defender. And I said, there's a conflict here, there's a big conflict, because both of you represent basically the same law firm. The public defender representing the defendant wanted the defendant released. The public defender representing the victim was opposing for release. I says, you can't do that. So I said, pick and choose, which one will I be? Since I have the power to eliminate the public defender representing the defendant, I eliminated and appoint the APD to avoid that conflict. But that's happened several times in other courtrooms. And you know, that's why I really was reluctant to the civil law center. And I wanted to limit it to a very limited number of cases where there are victims involved. I think that for some reason, the Guam Legal Services Corporation dropped the ball because they usually represented victims in these type of cases. I still remember when I used to do a lot of the POs, it was the Guam Legal Services Corporation that represented the victims. Okay, and the public defender. represented the defendant. And usually, I still remember in the civil hearings, because that's when the domestic violence judge also did the POs, because we knew what the right hand was doing from the left. Right now, we don't even know what's happening in the POs, because we don't have any knowledge of that. But I always requested the public defender would sit in the hearings for the PO cases, because, you know, in case their client incriminates themselves in the hearing. So the public defender was always there representing the respondent in a PO case. But now we're seeing some conflicts, but you know, I think through careful screening, you've been able to eliminate most of those conflicts. But I still feel that if you do represent a victim and you are appointed by the court to represent the defendant, that you immediately has to be recused and have APD or somebody else represent the individual. But that was the whole reason why we put a moratorium, one to the race to the court, race to the public defender, which are a very common term at that time in the sim. In the 80s, remember the word race to the public defender, you know, and people were crying because my wife or my husband beat me to the public defender. I lost custody of my children, of my property, all this, blah, blah, blah. And so we eliminate that one, and also conflicts. And now we're back to square one. So we're gonna either tighten up the representation of the Civil Law Center to avoid as many conflicts as possible, or to.
Do you think the
moratorium.
separation of the civil division into separate offices minimizes the conflict of interest in case of difficulties that were previously faced? I mean, that's one of the whereas clauses in the resolution. Or are you proposing an amendment to the resolution?
You know, I don't know. I guess we put a China wall.
And you
But
know,
it-
to
it's-
reassure you, there already is a wall. They're in a separate building. They have a separate case management. I don't even have access to their office. And so we don't have access to any of their files. The conflict wall between PDSC and CLC is identical to the conflict wall that has been existing between PDSC and APD since APD was created. So if the wall between us and CLC is not good, then the wall between us and APD is.
Yeah, but APD
Not good.
was created as a conflicts. Okay, their sole purpose was to represent independence that you excused yourself from or were conflicted out. So they're created mainly for being a conflicts firm. And the Civil Law Center is, I don't know what it is.
Well, it's to
in civil
fulfill our
cases.
statutory duty to represent indigents in civil matters. I mean, if the Guam bar could go
Well,
to
you
the
know, if you talk to
legislature and
most
ask
of
them
the,
to
you
remove
see
it.
most of the public defenders in the States, they do only criminal work.
Exactly.
And
I mean, Guam is,
when I go to conferences and I see somebody from public defender, and I explain to them the public defender does civil and domestic, they're surprised. Wow, you know, you can only do criminal.
yeah, and this is the trend going forward because the American Bar Association supports the civil union. And it's just a matter of time before the rest of the country catches up to Guam. We've been doing it since '75.
Well, the legislature does have a specific provision, you know, authorizing the public defender to, under its statutory authority to render legal aid and assistance to those who are in economic need of legal assistance and representation. Of course, they can't accept fee generating cases, and the legal assistance in civil matters can only be given to those who would not otherwise receive such assistance. And I think the funding that the civil moratorium received this year is contingent on them being able to provide certain services in certain areas. So I guess the question, PJ, that you're wondering is, what is the breadth of that? And I think that question is still outstanding because even the Civil Law Center has not determined the types of services and representation that it wants to do yet, because they want to engage in this community-based needs assessment survey to determine the priority services. And then based on that, you know, go forward. So
Maybe we should table this and then have them provide that list for us to consider.
Carol, can I hear from you about that? Can you provide how long do you think it'll take you to identify the priority legal services that we'll need so that the moratorium lifted will not encompass some of the services that may be deemed to be a priority, but would be one that the board might not be comfortable approving because of its potential for ramifications in a variety of areas.
So I just wanted I was going to actually speak and chime in earlier when you were talking about the mandates under Guam law. The civil division is created under the Guam law, and then also one of the provisions of the Guam law, which is section 11106, the powers allows the corporation to do any and all things necessary to further the purpose of the chapter and to perform the duties that are imposed under the above sections, which is the criminal representation and civil representation. So that's why we separate ourselves similar to that of APD. You know, it's provided statutorily under the Guam.
We don't have a problem with that. I mean, you know, the limitation in 1105 is to giving legal assistance to civil matters only to those who would otherwise not receive such assistance. But in the resolution that we have pending before us, what PJ has referenced is you say you're going to determine the types of services that you want to prioritize based on this community-based needs assessment.
That's correct, Your Honor. So under the grant, we can determine and identify those needs areas, basically utilizing what we've already captured. But for the local funding, so currently we're providing guardianships over minors that are uncontested. We also would like to do establishment of paternities. And those are all. And then, of course, we're assisting veterans, and then we're assisting the elders. Our grant only limits us to 60 and older. So that would allow us to incorporate the 55 to 59 bracket, which is why we'd like the moratorium to be lifted. So the local fund, that is where the local fund is going to kick in, is we're providing these services right now, Your Honor, and these services are not something that is permitted under the grants that we currently have. Luckily, ARPA was what allowed us to work on providing these services. And so that's why we're asking for the moratorium to be lifted, because even at that, the services that we are limited in providing, that's under the resolutions, that should be locally funded. Like the war claims should be locally funded. We're still handling cases of that nature. The other areas is the court-appointed guardian ad litems. I know Attorney Ariela brought up there's no civil. There are some civil mandatory constitutional cases where there's constitutional rights, like involuntary commitment. That's a constitutional right to an attorney, a public defender under Guam law as well. Then we also have, appointments in PINS cases and juvenile cases. That's quasi-civil, not criminal in nature. So that's a civil representation that's constitutionally, that's mandated by law. It's constitutional that they be appointed attorneys. And so those are the cases that we're looking at incorporating. And then, of course, the concerns of divorces, I get it. We also want to work on things that are set, like that are going to settle. If we are to go into that, it would be uncontested divorces, uncontested custodies, because we're having issues with people getting public assistance because they're married but legally separated for 20 years, and now they can't be the head of household because they got to claim their estranged husband. And so those are the areas we're looking at, Your Honor. We're not looking at anything that's fee generating. We're not looking at taking a probate case where we believe that, as they mentioned, there may be a lot of properties. We're looking at whatever the statute under Guam law permits, which is they got to be rejected by 3 private bar attorneys, and it has to be consensual.
Well, that rejection, I'm not so sure that applies to the 1105. That was the 1104 rejection was for probate. Recovery of probate claims. Yeah, it's not the general thing.
Correct. I meant just for probate matters, Your Honor. I apologize.
Jackie, you had your hand raised.
Yes, Chief. I was going to ask whether or not you wanted me to withhold discussion until the board is prepared to discuss the matter and prepared to vote, or would you like me to address my commentary now?
Well, you can hold off, and who else has their hand raised? I can't really see.
That's her as well, Your Honor. She's on two.
Oh, you're on, okay. So you might as well talk now, Jackie. I thought that was you, but then you talked on the other line, and so I wasn't sure. Go ahead.
Yes, Your Honor. I am creating confusion by having my face on one and my voice on the other. In terms of my thoughts, right now, the Private Bar Association is compelled to perform appointments in the criminal indigent defense system. And my concern is that if there are insufficient attorneys to provide criminal indigent defense, then I do not agree that the Public Defender Service Corp should expand to civil litigation in the midst of this type of system. So the question that I have really is, to the extent that our Civil Defense Center has now represented that there is simply no conflict because there is a wall between the public defender and the APD as it relates to the Civil Defense Center, then the question is, well, then if the civil bar is compelled to perform criminal indigent defense, then shouldn't we treat the Civil Law Center in the same manner? That if they are going to be taking on civil cases like a civil practitioner, albeit with certain restrictions, then shouldn't we also treat that as a potential, and I know I've made jokes about this, but I've said the otro defense bar, right? So we need another system in order to augment the primary mission of the Public Defender Service Corp, which is criminal indigent defense under Gideon. So that was my first thought on it. My second thought was kind of the concerns that we have over the same board controlling all of these bodies, right? Controlling is a word I'm using very loosely, right? Relatively, but that we are responsible overall for all of these same boards. And we still have an outstanding ABA, not outstanding, but we have an ABA report that suggests that we reconsider the participation and the involvement of the judiciary of Guam in our system in order to ensure that indigent defense is properly protected. And so now we're going to be adding more to a pot, which we are already considering modifying in some way or another as it relates to its governance. And then finally, I agree in the sense of a restriction on the lifting of the moratorium. I cannot agree to a complete lift. And so I do appreciate Ms. Hinkle-Sanchez's efforts in putting together this community-based research to determine what areas are most needed. And I agree with Attorney Arreola that divorce is not a constitutional right. That if people want divorces, they need to pay for their own lawyer. So contrary to Mr. Hattori's position that you're taking money from the mouths of the private attorneys, that's not our concern here. I don't think the private bar, and I think our survey, what is it really responds to that the private bar is not concerned about money being taken from them. That's not the reason why there appears to be some objection. The objection really is as it relates to our primary mission, which is criminal indigent.
All right, thank you for those comments. Presiding Judge?
Yeah, I'd like to move the table, but I'd like to maybe make a request to Carol. That she did mention that, you know, the list of services that were required under the Civil Law Center. Maybe, because to me, that's a policy issue. It's not an issue for the staff of the Civil Law Center to determine what type of cases are going to be taken and what kind of cases will not be taken. I think it's a policy issue that should be determined by the board if we're going to permit this, okay? So I'd like to maybe table this with the request that in the next meeting, Carol be asked by the chairperson to come up with a list of potential cases that we can look at, and then we can determine which cases will be represented by Civil Law Center and which cases will not be?
I think we can do this incrementally too. So if you, Carol, come up with the listing, we can pass the resolution, modify it the next time to include specific type of services and start with those services and then re-examine the appropriateness for expanding it to other areas. So if you can get that to us, I think by the next meeting, because I am clearly in favor of providing, the services that the legislature has expressly authorized and provided some money for us to be able to deliver those services, and we should take advantage of that and work towards that. So I think if we can identify specific services that we'll start with, and then, get a report on how that's working, and then in addition, maybe do an incremental approach and towards expansion of those services. Start slow and make sure that it doesn't create any uncertain issues for us that we perhaps didn't envision, and then we can seek to expand it. So
I'm perfectly fine with that. I don't even really want to have anything to do with it, just to maintain the law and
Yeah.
complete safe parallel.
yeah, and so we're gonna ask you to put that together, Carol, complete the needs assessment. And identify for the board what types of services and representation you want authorization for specifically when we vote to lift the moratorium. And we'll vote to lift that at the next meeting with those specific services identified. Okay?
Could I just add one thing? I'm just a little concerned about the use of money that the legislature said was to use for civil matters to pay for criminal stuff, because I think we might get in trouble with the legislature if that happens.
No, we should not use it for any criminal stuff. Not at all. I think you can use it for some of the guardianship.
Oh, yeah,
stuff.
so and that's what we were
That's
hoping
civil
today,
side.
that CLC could be added to the guardian ad litem panel, because they're not on there, but they can just.
Well, there's other cases that I don't object. Civil Law Center, like guardianships. Many people need guardianships. Now, to me, that's a non-conflicting.
Maybe,
case.
maybe not.
Well, yeah. But I used to represent guardianships at 99.9%, there's no conflict. Okay.
Okay.
Well, let's get the list at the next meeting. Carol,
If
the
I may.
specific services we'll start with. Okay?
Your Honor,
Alright,
if I may, can I request then? Of course, I'm pushing for the vote on the lifting of the moratorium, that maybe perhaps we can make amendments to the current resolution that's submitted, and at this time lift the moratorium, and under resolution number 1312, the court permitted public defenders, it'll be now Civil Law Center, to handle uncontested guardianships, burial of expired bodies. Again, Your Honor, these are services that are not provided for or not permitted under federal grants. And we're currently doing those services right now, which is why I'm requesting the lift of the moratorium so that we can continue to provide undisrupted services. So if we can amend the resolution, because those are already identified areas that that the board agreed to, which is uncontested guardianships, burial of expired bodies, domestic cases that involve or family
But
violence.
what is the proposed language that would be that you're looking to get amended?
Basically that we would change, I'm looking at the resolution right now, Your Honor, I apologize.
Can we go down to the second page on the resolution, please?
I have the resolution in front of me.
So maybe third paragraph to the top where it talks about the moratorium involving civil and domestic imposed. Maybe it'll be lifted, and services shall be limited to provide the following services shall be limited to provide for uncontested guardianships. I'm sorry, I'm looking for my old one now. Burial of expired bodies. That's actually the right of sepulture, because we actually have an increased numbers in that right now. And all the stuff that was authorized in in the legislative, the budget law, which is representing victims of family violence, representing the elderly, and then of course, veterans, at-risk veterans.
All right, so the proposal is to add are hereby lifted for the following services. And it will be uncontested guardianships, burial, what was the term?
Burial of expired bodies, and then
A
it's
burial of
Guam
expired
war
body.
claim, it'll be Guam war claims as well. Which is what we do, there's a special
Okay,
statute that
one more claims, and what the other three.
at-risk veterans, elderly. And then, of course, services to our elderly, and then protective orders for victims of family violence, sexual assault, and stalking.
All right, so that's the proposed amendment lifted for these particular services only. And then we'll delete the last resolved for the time being. Or you can, I guess, still go through it, but since it's only going to be limited.
Can I amend that list?
Yes, go ahead, PJ.
On the guardianship, can we just make it for juveniles for now? Because adult guardianships can be very tricky. Okay. And
What about
civil law
disability?
center, you represent that, that's gonna be very complicated now.
Guardianship for disabled?
Disabled adults.
No,
No,
that's what
it's
he's
too-
talking about.
That's very, you know, because you have,
I
I
think there's
So-
enough work.
think juvenile.
I think there's
juvenile
enough
is
work
okay.
there with that. So with
Okay,
that
that's
amendment
good
as
now.
proposed by presiding judge, he's making that proposal with that list. Can we just restate it to be clear? You got it all down? Or do you want me to
Is-
try? Let me
Chief-
try it. So
May
it's
I-
going to, go ahead.
May I inquire why we're creating civil and domestic cases?
No,
If
it's-
we're
it's
already
being-
creating a list, it would be just a moratorium involving civil cases, correct? And
Yeah,
then we're
it-
lifting it with respect to certain restrictions.
So for certain.
Yeah,
cases.
because even it's the more, even if you left that in there, Jackie, that the moratorium involving are hereby lifted for only these following cases. So the
Okay.
moratorium is still in effect except for these identified cases.
Okay,
So the moratorium still would apply to civil and domestic cases other than these ones. So I
Okay.
think you could leave the domestic. In fact, you probably would want to leave that in there.
okay,
We're not lifting the moratorium involving those, because the qualifying language is lifted for only these specific services. Right?
yes, I understand that that's what we're trying to do, accomplish at least today. So can you go through the list one more time so we can make sure that we have a definitive list?
All right, so it's hereby lifted for uncontested guardianships of minors, for a burial of an expired person, for at-risk veterans, for seniors, for Carol, help me with
One more clean,
Guam war claims and
On Penn's cases.
no, and one more,
the family violence. victims.
family violence, yeah. Yeah, victims of family violence. So those 6 categories. So it's gonna read that resolve clause is gonna be resolved that and all previous are hereby lifted for only the following services, and they'll list those 6 and be further resolved that, the restrictions.
Can I just clarify the family violence? What kind of cases would you
Protective orders.
Protective
When-
orders, Your Honor, is what we're doing.
where the public defender is not representing the defendant, right?
Oh, we have a China wall, Your Honor, between us.
Same problem I had in my court hearings.
So yeah,
you
we
know,
have a China wall,
You represent the
that,
victim and then public defender represents the defendant. And we're going back to square one again, and we have to kick out public defender in the criminal case and appoint APD.
Why? Why would you have to if there are separate offices? Like
Well,
APD
because-
has.
Just maybe, the name public defender, especially when it's a contentious release case where, the defendant wants to be released by a public defender criminal section. But the public defender in the civil section is opposed to release.
The
That
Civil
puts-
Law Center.
Yeah, but that puts a complication on the attorney, on the judges. Because, you know, the defendant that will be, because I've been asked by the defendant at one time, why is public defender, keeping me in jail as well?
Christiana's got about 5 minutes remaining before she has to leave.
I have to leave too, because I'm.
Your Honor,
And
we
see it.
we feel like there's an adequate wall in place to survive any legal claim or any ethical claim against this practice, but I mean, maybe we can just get some briefing done and show the court how this has been done in other places, so there's some additional level of comfort there, but we feel like with the separation, Steve has no access to these files that we're doing it correctly.
Motion?
Well, there's a motion made by PJ originally with that amendment. Is there a second?
I'll second.
To just include juvenile, right? Yeah.
The guardian.
With
Your
that's
list,
amended,
your
right?
list
Yeah.
as amended.
The list as amended. I mean, do you, okay,
Still working.
so,
I'm still hesitant, and I think that's okay.
alright. Well, that's part of the reason we'll examine it, and if it runs into issues, we can make the changes as we go along, and that's why we'll do it incrementally. So, okay, it's been moved and seconded with the resolution as amended. All those in favor say aye.
Aye.
Aye, there being no objection. Jackie, your position on the resolution as amended?
On the amendment that we have, yes,
Yeah.
but we still need to address the last resolved clause. So
Yeah,
I think that we need to address the resolve, the Civil Law Center shall determine. I think the PJ has also raised the issue that it's not the Civil Law Center who shall determine it, but really that this lift of moratorium, that the Civil Law Center shall prepare the assessment for consideration by the Board of Trustees.
Because I agree that's a
Yeah.
policy issue that the board has to consider, not the individuals at the Civil Law Center.
And so we
So
can
perhaps-
just add.
Perhaps that's a motion, I don't know.
Report the results of that survey to the Board of Trustees for
Yes.
appropriate action.
Mm.
So if you can make that amendment to that last resolve, there's an amendment by trustee Tilahi on that, and report the results of that needs assessment survey to the board for appropriate action. Is there a second to her motion?
I second.
Second by Christiana. All those in favor say aye.
Aye.
Aye, there being no objection, that passes. All right. On the resolution now as a whole with those two amendments, all those in favor?
Aye.
Aye, there being no objection, it passes. All right, thank you. Let's move on now. We are in tight business in order for us to get to executive session. Quickly on the agenda, if we can, there's a report, I guess, on the historical evaluations that you wanted to provide on both of them.
Yes, Your Honor. So on page 30 and 31, there's a brief historic report regarding past executive directors since 2003 with Ms. Kathy Maher and forward to our current executive director, which shows basically that they were retained or if ratings were given through evaluations, and also like, for example, in bullet number 4 on the first page, March 1st to 2013, March 1st or 21st to 2014 with our executive director Miller, there were standards and categories of his evaluation, and then his outcome of that evaluation, then all the way to our current director Hattori, who was last evaluated in 2020. Prior to that was in 2016 and 2017, with those categories of his evaluation study. And going back to 2020, he was evaluated again with favorable results. However, due to the economic circumstances of COVID and the times of that period, the board, made a consideration for holding off on increments. Mr. Hattori did agree with it. However, those financial circumstances never really did pan out. So basically, in the opinion of this letter that I wrote regarding the 5 GCA law that I cited, basically states that every year there should be an evaluation done by the board on its director, on the executive director. And therefore, at that point in time, the board can decide whether the evaluation is favorable or not, whether he's due for an increment or not. And I'd like to bring back again that he hasn't had an increment since 2020 or since 2017 timeframe. And therefore that created that other discussion we had earlier on the pay chart. So I would think the proper thing to do at this point in time was to implement the 2020 pay increment to Mr. Ottori as due, as he has been satisfactorily performing. And then that does not preclude the current evaluation or include that current evaluation at this point in time.
Okay, thank you. The, as we determined before, we decided that we would deal with the salary issue based on after the overall evaluation as well as the classification, because you know, there's a issue about whether he should be on the attorney pay plan, the executive pay plan, classified, unclassified. You know, there are some issues that have come up with regards to that discussion. And the board is evaluating all of that and will make an appropriate decision. And so the next item then on the agenda, and I presume you have the same information or comparable information.
Yes, Your Honor. I'm a little more with consistency with Ms. Gill due to her job classification as classified. So her evaluations fall under and in line with a classified employee and has been consistent with the evaluation and ratings. And so I kind of highlighted the outcomes of those periods. And again, she is currently due for an evaluation and rating.
Right, which is the board is currently
Yes.
undertaking. Okay, then the next item on the agenda, real quick, because I know everyone has to leave, is PDSC. Can we come back to the PDSC donated leave bank policy after executive session and the and then Survey Monkey results is going to, they just for the record, they've been distributed to the executive director and the managing attorney, and also been given to the all of the board of trustees. Then there's an open government law and board of trustees executive session memo. A response was sent by me to the memo that was sent by Robbie Cole. I think there's also some other issues concerning that, but we can talk about that some other time. So if we can, and we can come back to the PDSC donated leave bank after executive session, is there any objection to?
Is that a controversial issue?
Do you need action on that today? PDSC donated leave bank policy? No?
Table that
Okay.
for the next
All right, we'll table that. So if we don't mind, can we recess from regular session and go into executive session briefly?
I know that.
And she's gotta go and.
We have three.
Are we, turning off the recording?
I'm a jury.
Well, we have the recording will be off session. We should some action, but yeah. We should. Yeah.
That's all.
But it's.
There was a question I made to ask you, so whatever clears the room.
Well, let's just take minutes. We took minutes the last time, but for us, we've always had it. I don't think it has.
Oh, next to here, right?
back in regular session, and I'll recognize Presiding Judge Lamarina.
Oh, okay, we would rise, we're going to ask both the executive director of APD, I mean, public defender, and the managing director for the APD. To give a report about, you know, your justification why you should be retained in your positions, okay?
No, actually, we just want a response to the performance
Yeah.
evaluations.
Basically,
Yeah,
to
I mean,
why.
PJ, you can add that why you, if you want to, but I think, you know, both of you received the performance evaluation. We feel it's only fair that you have an opportunity to comment on it.
Because there were some responses where, you know.
Yeah. Well,
you might
whatever,
want to respond
both
to.
good and bad. And so you'll get a chance to comment on it and then meet with us in executive session, each of you at the next meeting as well to go over it. And we hope to be able to, you know, put this and get it done and then address the compensation and classification as well. Okay? So that's a motion by presiding judge. It's second by Christiana. All those in favor say aye. Aye.
Aye.
There being objection, that passes. And if you can, if you can give us just your written response in advance of the meeting would be good. And then we'll also ask you to meet with us in executive session at the next meeting to just go over the evaluation. Yeah, not together, yeah, but individually. Yeah. All right, so with that, if there any public discussion? All right, there being none, we'll adjourn. Our next meeting is Tuesday, the 26th at 12:30. That's Thanksgiving week. Thanksgiving is Thursday, so. All right, there being no objection, motion by presiding judge to adjourn, second by trustee Munya, the Kanata.
Thank you.
And there being no objection, we now stand adjourned.
Thank you.